Hi, welcome back to Finally Revealed. In this episode, I want to go over a bankruptcy term, and that is a small business bankruptcy case. In another video, I'm with my friend Lisa Epps, and she's talking about small business bankruptcies, and this comes up, and there wasn't enough room in there to go into the definition, so I thought you should have that information, and so I will link these two together so that it will be clearer. A small business bankruptcy case is a specialized kind of a Chapter 11 case. Eligible to file it are people who are engaged in a commercial or business activity, but that business activity cannot be just the fact that they are owning and operating real estate. It has to be a different, beyond that, because that would be referred to as possibly a single asset case, where it's just the single asset, which is the real estate. So this is different. This is the small business bankruptcy. And that means with an aggregate, combined, non-contingent, liquidated, secured and unsecured debt, all of those kinds, in an amount not more than $2,566,050. And that amount is as of April 1, 2016. There was a lower amount before. Now it's a little bit higher. So non-contingent, which means no conditions would trigger the amount of this debt being owed. So this debt is owed without conditions, and it is liquidated, which means it's not something that you're not sure of the amount. You're sure of the amount. And it's both secured, which means there's collateral for it, and unsecured, which can be trade debt and other types of debt that there's not collateral for. So the known debt that doesn't have conditions, whether it's secured or unsecured, the whole pile of it has to be not more than $2,566,050 as of the date of filing or the date that an order for relief is entered. Now, as you know from another video, the order for relief is automatically entered by the clerk, well, on behalf of the court, once a debtor voluntarily files a bankruptcy case. When there's an involuntary case, which means it's filed by a creditor against a debtor, that's when the filing and the order for relief don't automatically match up. So that's why that provision is there for a small business bankruptcy case. Okay? And as of the filing date, there has not been an unsecured creditors committee appointed by the U.S. trustee, either because they haven't gotten to it yet or because the court found that wasn't necessary. And this is something else that you need to know about. An unsecured creditors committee is a committee of the 7 biggest unsecured creditors, or it can also be equity security holders. That is something that automatically follows with a Chapter 11 bankruptcy case. And so in order to make these qualifications fit for someone to file as a small business debtor, they need to, at the time of filing, ask the court to not appoint an unsecured creditors committee. And that is allowed. So that will be something that you'll talk with your attorney at the time that you're getting your schedules and your petition ready to file, so that you qualify as a small business bankruptcy case. I hope this was helpful. If there are any questions, leave them below, and I will link the video where Lisa's talking about the small business bankruptcy case, and hopefully this will help you. All right? If this was helpful, leave me a thumbs up. Again, leave any comments below. Share this with anyone who may be involved in a small business who's considering a bankruptcy, so this might help them. And subscribe to see our other videos, and come back and see me next time. Thanks for watching.